Okay, 620. This has to do with arbitration. It's pretty simple. I assume the company is aware that with some of the recent decisions that have come down from the CFPB, the Consumer Finance Protection Bureau, that they recently had tried to adopt an arbitration rule, which Congress rejected. Within 2 weeks of that, I got a flyer in the mail from my Discover card sticking in me with an arbitration provision in my credit card agreement. And I suspect everybody in this room probably got them also, though probably nobody read them. But arbitration is on the rise. It's out there. They're sticking it in every contract for just about every transaction you do as a consumer. And all this bill says is that if a lawsuit's filed and a judge denies a request to send something into arbitration, that cannot be appealed to an appellate court until the case is over, like any other issue. I think right now you can take an interlocutory appeal. It's one of the few things you can take an interlocutory appeal on is a denial of arbitration. And in Virginia, we have a strong preference towards only appealing final orders. And this is one of the few things the federal government has not preempted. I think we ought to take control of it, exert our states' rights, and prohibit denials of arbitration until the case is over.
Mr. Chair.
All right, Senator Peterson.
Okay, I've actually had an interlocutory appeal taken against me, and it was successful, so I may be the one guy. Scott, what happens, though, if there's arbitration is raised as an issue, you beat it at the trial court level, you go and get a multi-million-dollar jury verdict, and then it goes up on that issue, and then you get vacated?
Yep, that could happen.
Yeah, that would suck.
Yeah.
Yeah. And
It would.
I would say also, I mean, if I'm going to lose a case, I'd just soon lose it early.
I agree with that.
Looking for a response here.
Yes.
I mean,
Isn't that so?
No, I mean, it would, and that's the theoretical possibility. And of course, what this bill would do is it'd give the plaintiff the ability to decide whether or not they want to do that in an interlocutory appeal instead of having it shoved down their throat. And so, I think that the plaintiff ought to have that choice. I don't know why the playing field ought to be tilted to say that only the defendant gets an interlocutory appeal on this, as opposed to having it like any other issue that we decide. So that's why I think we ought to at least have the option that gives the plaintiff the ability to participate in the decision about whether or not to do the interlocutory appeal. And you can assess whether or not you think you're going to lose the arbitration issue on appeal or not as part of making your decision when talking to your client about it.
All right, other questions to the patron? Anybody wish to speak in favor of this bill? Anybody wish to speak in opposition to this bill? Anybody care about this bill, other than the patron?
Well, I can tell you, I can tell you, there's an organization that I've been working with on it and brought it to my attention. They're in D.C. American.
I thought we were talking about states'
public
rights.
justice. Public
okay.
Justice.
All right, bills before us.
States' rights. That's right.
Yeah, Mr. Chair, I'm going to move to PBI, and I like most of Scott's bills. This one I don't like.
Yes, Senator Normant moves and Senator Peterson seconds the motion to pass the bill by indefinitely. Clerk will open the roll. All right. Oh. There we go. All right. Bill's passed by indefinitely.